Hello, everyone. Good morning, good afternoon, good evening, depending on where you are. My name is Mike Swift. I am the Chief Global Correspondent for Data Privacy and Security for MLEX. We are a global news organization that covers the intersection between technology and the law, and my team focuses on the intersection between data privacy and regulatory agencies and the courts. We have a great program for you here today. Across the Americas, from Buenos Aires to Washington to Ottawa, we're seeing regulators increasingly focus on the data of children and minors. In the US, even as we see a pretty sharp policy switch to the Trump administration this month, it appears that emphasis will continue. When the Federal Trade Commission issued updated, tighter enforcement rules for the Children's Privacy Protection Act this month, incoming Chairman Andrew Ferguson voted in favor, despite his enmity to FTC rulemaking in general, saying that the new rules are the culmination, quote, of a bipartisan effort initiated when President Trump was last in office. In Canada, Privacy Commissioner Philippe Dufresne has identified children's privacy rights as one of his 3 strategic priorities during his term from 2024 to 2027. There's been a focus on kids and minors' privacy issues across Latin America as well. Across the Americas, we're seeing regulators increasingly concerned about the collection and use of kids' and teens' personal data, including a focus on data minimization and concerns about the allegedly addictive design of social media platforms fueled by that data. We're also seeing plenty of action in the courts involving kids' personal data in both the United States and Canada, involving allegedly addictive design that younger users are particularly prone to, including litigation filed by more than 40 US states that have sued the likes of Meta, TikTok, and other social media companies on those allegations. We're also seeing a focus across the Americas on issues around the crossover between artificial intelligence and child privacy, such as regulators' focus on the responsibility of AI developers, providers, and organizations using generative AI to identify and prevent risks to children. Today, we're going to start by focusing on children's privacy issues before we verge into issues around AI and kids. Our plan is for our panel discussion to last about 30 minutes, at which point we'll switch over to questions from the audience. You can ask questions on the chat function of this platform, and you can also use the comments section in LinkedIn or YouTube, and we will see those questions and recognize members of direct them to the panelists. So we have a fantastic panel today, starting with Kristen Pennington. Kristen is a lawyer and partner in the Privacy and Data Protection Group of Macmillan LLP, a Canadian business law firm with offices across Canada. Kristen specializes in helping international businesses comply with their obligations under the patchwork of Canadian privacy laws and regulatory guidance. And she regularly advises on the privacy and data protection implications of new products, services, and initiatives. She joins us today from Toronto, Canada. Next is Mason Clutter, who is a partner and privacy lead at Frost Brown Todd. She has over 15 years of experience as a lawyer and policy advocate in Washington, D.C., where she now advises clients on privacy and data security matters. Mason previously served as the Chief Privacy Officer to the U.S. Department of Homeland Security, where she advised the Secretary of DHS, heads of DHS agencies, and worked with the National Security Council on privacy implications for national security and law enforcement initiatives. And third, we have Mariano Peruzzati, who is a partner with the law firm OHAM BF in Buenos Aires, Argentina. Mariano regularly advises clients on a wide range of IP, IT, and privacy matters. He has extensive experience in assisting international and domestic companies in multinational data protection compliance projects, coordinating the assessment of different jurisdictions, and addressing the local requirements with a global approach. He currently serves as co-chair of the Buenos Aires Knowledge Net chapter for the International Association of Privacy Professionals, the IAPP, and he's also a member of the IAPP Academic Advisory Board. Welcome, everybody. It's great to have such a great panel here this morning. Okay, so we're going to jump right into questions on issues around children's privacy. And Mariano, I thought I'd start with a question to you. Minors' data privacy is a highly relevant issue in many regions across South America, including Argentina. How is the processing of children's personal data regulated in Argentina? And what recent actions has the Argentine Data Protection Authority taken in that regard?
Hello, Mike. Hello, everyone. First, let me say thank you for all of you for having me here. It's a pleasure to join this panel with outstanding colleagues. And thank you, every one of you, for joining our panel today. Well, it's a very interesting question, Mike. First, let me tell you about the legal landscape here in Argentina on data protection. We have a very old law. This law was enacted in year 2000. It's the Argentine Personal Data Protection Law, inspired on the EU directive on personal data protection. This law does not provide for specific rules on children personal data. Rather, the general rules will apply here. Previously, it was considered that as any other civil act, the processing of personal data of children under the age of 18 years will require the parents' consent. However, in year 2019, the Argentine Data Protection Authority issued a rule number 4, which recognizes the principle of progressive legal capacity. Which is the meaning of this principle? Well, it says that in certain cases, teenagers can give their consent, informed consent, for the processing of their personal data. If the minor does not have enough capacity to provide the consent, then we will have to obtain the consent from the parents on behalf of the kid. Since the regulation did not provide any concrete specific definition on the age of majority of a person, it has always been very challenging to determine whether a minor in a specific case can give the consent. So the approach of this rule 4 of 2019, was very hard to implement. However, recently, in December last year, the Argentine Data Protection Authority released a set of guidelines providing information and recommendation on personal data protection specifically addressed to teenagers. These guidelines states that when a 16-year-old or older teenager consents to the processing of his or her personal data, there is no need to obtain an additional consent from the parent. So a consent of a teenager in certain cases will be valid. So now we have a kind of rule that when dealing with specific services addressed to teenagers, any person older than 16 years old can provide the consent. Finally, let me say that Argentina, jointly with Mexico and Canada and other state members, such as the UK, signed a joint statement on the protection on privacy implication of age assurance method. This statement outlines essential principles directed to companies operating websites. The statement called for the implementation concrete of age verification systems to ensure that consent is appropriately tailored to the user age, such as, for instance, self-declaration, the use of AI facial age estimation, and the verification of ID. I will stop here for the moment.
Thanks, Mariano. Appreciate that. Hey, let's jump north to Canada and to Kristen Pennington. And as we mentioned in the introduction, the Office of the Privacy Commissioner of Canada and other regulators have identified the privacy rights of children as a strategic priority. In your view, what are some of the recent actions that regulators have taken to demonstrate their commitment to championing the privacy rights of young people? And from the point of view of organizations who process the personal information of minors, what do they need to be alert to in terms of potential areas of enforcement?
Thanks a lot, Mike. Thanks so much for having me today. So, you're right. Canada's federal privacy regulator has expressly identified children's privacy as one of only three strategic priorities over the next few years. And in particular, the federal regulator has said that they intend to prioritize investigations and assessments of data breaches that involve children's privacy or children's data. And they've also said that they intend to collaborate with provincial privacy regulators in Canada as well as international privacy regulators to identify emerging threats to children's privacy and also to engage in joint enforcement activities so that they can have a broader impact in this area. So, in my view, this indicates that the regulator may also be more inclined to publicize the findings of its investigations as they relate to children's privacy, and they may potentially name organizations that they find to run afoul of Canadian privacy legislation, as well as the various guidance that's been issued governing children's privacy rights in Canada. The issue of children's privacy also came up in a recent report issued by the federal regulator in connection with a sweep of various websites and apps for what they call deceptive design patterns. And for those unfamiliar with that term, deceptive design refers to the use of different design elements on websites or on apps that, in the privacy regulator's view, influence, manipulate, or coerce users to make privacy related decisions that are not in their best interest. So, for example, those may include design elements that prompt an individual to provide more personal information than they otherwise might like to had the deceptive design pattern not been used. The report concluded that certain deceptive design patterns occurred significantly more often on children's websites and apps than on those that appeared to be aimed to the general population. So, for example, the regulators found that making the option to sign up for an account much more prominent than the option to continue using a service without creating an account, or the use of shaming language to dissuade children from deleting their accounts were quite prominent on children's websites and apps. The report also included a number of case studies with screenshots that showed very specific instances in which the regulator alleged that organizations had used deceptive design patterns on platforms that were targeted towards children. So, again, I think this points to Canadian privacy regulators being willing to name and shame organizations that, in their view, aren't getting the issue of children's privacy right. And then just last week, in a very timely development, although an unfortunate one, the federal privacy regulator here issued a statement indicating that it is, quote, in contact with an organization named Power School, which is an education technology software company that provides services to a number of schools and school boards in Canada. Unfortunately, they recently suffered a fairly significant data breach that reports say has impacted more than 2.4 million Canadian students. So it remains to be seen whether the regulator will actually initiate an investigation, but at the very least, again, they've taken note of the incident. They've made a public statement naming the organization, and it seems that they're closely watching how the company will respond to the breach. And then to the second part of your question, in terms of potential areas of enforcement, I'm sure we'll touch on these more throughout the session, but I think we will see an emphasis on the concept of data minimization or ensuring that organizations collect and use the minimum amount of personal information of minors as is necessary for reasonable business purposes. I also think, as Mariano alluded to, we'll see maybe more guidance and potentially enforcement action around consent in the form of consent and how you present privacy related information in an age appropriate manner. And we're seeing that as one issue that's come up in the Canadian privacy regulator's ongoing investigation of TikTok. I think appropriately safeguarding children's personal information will be another hot topic, particularly given the relatively high profile breach I've just mentioned. And lastly, our regulators here put a lot of emphasis on privacy by design and ensuring that organizations are considering privacy issues from the very outset of developing or designing an offering for children. So I expect we'll see more guidance and potentially some enforcement action in that area as well.
So the message is look out for naming and shaming by regulators in Canada. That was a really interesting report on design of children's apps and websites. We wrote about that. Over to Washington, D.C., which is certainly a very interesting time to be in Washington. with the changeover to the new administration. Mason, with the new year, we saw big changes at the federal level. And as part of the flood of news preceding the inauguration of President Trump, the FTC released rules implementing COPPA, the Children's Online Privacy Protection Act, on January 16th. And I was wondering, could you walk us through some of the most significant changes and when we could expect to see some enforcement under those rules?
Yes, absolutely. So thanks, Mike, for having me, and thank you, Privacy Rules. It is really so much fun and interesting to be a part of a conversation across the Americas, because I really do think it highlights the similar challenges we're facing, the similar approaches to implementing appropriate safeguards, and kind of lessons learned. So thank you for hosting this very important kind of crossover panel discussion. But as you alluded to in your opening comments, in the United States, when it comes to children's privacy, it really is one of the few, or at least somewhat, bipartisan issues we have seen carry over across the last few administrations. And as you mentioned, about 2 weeks ago, we saw the first Federal Trade Commission, or FTC, rule change to the Children's Online Privacy Protection Act, or COPPA, since 2013, or as we know it, we can call it PTT, pre-TikTok. So this was about a 5.5-year endeavor to solicit public comments and finalize the rule. And as privacy protection practitioners, we know that the law often fails to keep up with technology. So I would say that generally speaking, the amendments were focused on this aspect of COPPA, or really including changes reflecting children's safety best practices online. So the final published rule is about 225 pages. So I'll go ahead and just summarize some of the most significant amendments, which include first, the threshold age. So I just want to note that importantly, the rule amendments did not and could not change the age of applicability, because this is something that is established by statute, and so of course would require a change by our Congress at the federal level. And as we've seen, we are nowhere near close to comprehensive U.S. federal privacy legislation in the United States. So even for children, so now the rule still remains that 13 is the COPPA threshold, or under 13 is the COPPA threshold. So along the lines of what Mariano was describing, we now have a specific and separate parental consent rule. It is no longer the case that parental consent covers the collection, use, and disclosure of a child's personal information. The new rule now requires a parent to separately and specifically opt in to targeted advertising. So this prohibits the sharing and monetizing of children's data without specific permission from their parents. And the same goes now for sharing with third parties. The new rule, while it's not necessarily a change, it certainly clarifies that separate verifiable parental consent is required before a company can disclose children's personal information to third parties, unless, of course, such disclosures are, quote, integral to the nature of the website or the online service. And along these lines, we're also seeing expanded disclosure requirements. So for instance, parental disclosures must list any and all third parties with whom a company will share children's personal information, including, interestingly, if they will make that information publicly available. So for each third party, the disclosure should also include the purpose of the sharing. What is the business purpose for sharing the child's information with this particular third party? And this goes further as it relates to COPPA notices, and it now differs from many state requirements that generally, at a high level with respect to privacy, require notice of categories of third parties with which information may be shared. Now, under COPPA, the COPPA notice must list every individual third party in their notice, not just the categories, but the specific third party. And not doing so will now constitute a COPPA violation. Generally, we also saw some important updates to definitions, including the definition of personal information, which now clearly includes biometric information that is used for automated or semi-automated recognition of an individual, and they specifically included fingerprints, handprints, retina patterns, iris patterns, genetic data, and face templates or face prints. And I'll summarize here or conclude here with just retention as well. The COPPA now requires written retention policies for children's data. And again, these are not just about retention lengths and periods. These now include the purpose for the collection, the business purpose for the retention, and the time frame for deletion, and a requirement that these policies must be made publicly available. And I will highlight that in the context of data retention, we saw a concurring opinion by Commissioners Bedoya and Slaughter, and that served as a reminder or even a warning that, of course, data cannot be retained indefinitely. And they were highlighting a concern that the interpretation of the existing retention standard for as long as reasonably necessary has inappropriately been interpreted as forever. And in particular, they highlighted a concern about the concept of retention of everything forever to train AI models, which is something that I know we'll discuss a little bit later on. And so we're really excited to get into that a little later. So lastly, the rule will take effect about 60 days after publication in the Federal Register, and covered entities will have about 1 year from the effective date to come into compliance, unless they're subject to other specified dates in the rules, for instance, those engaging in safe harbor programs. So I'll end there, and hopefully we'll get into a little bit more about the specifics with respect to AI and children in a bit.
Right. Yeah, so we're hearing the sort of the concept of data minimization, which is applicable across jurisdictions. And it looks like there's be a little time, though, before we see any enforcement under the new rule, given the publication delay and then the 1 year period to come into compliance. But look for that rule to be really significant down the road, I think. So we've talked about AI, so why don't we jump into that now? Mason, I'm going to stick with you with a question. In October, the world learned of a lawsuit in Florida that was filed by the mother of a teenager who died by suicide, alleging that the teen's interactions with an AI chatbot led to his death. And similar suits have followed, including in Texas. What do you think are some of the risks and considerations specific to children and AI that you've seen addressed in the U.S.? And what approaches are the federal government and the states taking to address the potential risks and considerations?
Thanks, Mike. So yes, we are dealing with these challenges in the United States, both through litigation as well as through regulation. And so what we see here is really a comparison of challenges in traditional online spaces compared to more immersive spaces like gaming and virtual reality that may blur the line between the physical and virtual. And they're challenging, of course, because while traditional notice and consent may be beneficial and easy to achieve in more traditional spaces, what we've seen from the example you highlighted in your question is that understanding that children operate in the world differently, primarily just because of where they are in their brain development stages, generally really is key to applying best practices to services directed at children. So this puts providers and developers in really unique and challenging spaces that they haven't been in before to truly kind of understand the way a children thinks and how they may actually approach in practice the products and services and tools that are being offered to them online. So common issues that we're seeing addressed include, again, the over-collection concerns and retention of data for longer than necessary. So those are some of the data minimization principles that Kristen was highlighting, really tying these collection and retention to only that period that is necessary to accomplish the primary purpose for which the information was collected. And again, these were noted previously in concerns that were raised by the FTC and elsewhere of retaining data indefinitely to, for instance, train AI models. And as you mentioned, Mike, when we kicked off the discussion, concerns about acquiring digital histories from children over the course of their lives, profiling related concerns, and even national security concerns. And not just on platforms that arguably are controlled by nation states, but as we saw with the previous administration here in the United States, their executive order on the bulk transfer of data, whether it's children's data or otherwise, to certain country can raise some of those national security concerns as well. So concerns around profiling, the use of inferences, decision-making over the course of children's lives, not just with respect to targeted advertising, but consider, for instance, use in college admissions, employment decisions, and use of biometrics. So those immutable traits that we really cannot change and that we carry with us over the course of our lives. Or even the use of AI by child protective authorities, right? These are big kind of questions that we're seeing and dealing with here. So again, default privacy safeguards that are enhanced when you are dealing with children are some of the measures that we're seeing being implemented at the state level. Requirements that companies conduct children's privacy impact assessments to identify potential risks and mitigate those risks on the front end, whether it's through those privacy by design practices that Kristen and Mariano were mentioning, or other safeguards that companies can implement to specifically address those identified risks. And again, in the United States, we are seeing these safeguards in children's specific laws, but also in general state laws regarding AI. So for instance, I would refer you to those comprehensive state AI laws. And when I say comprehensive, I mean not those that are used in a particular sector like employment or healthcare, but those that are generally applicable, especially in the United States as it applies to the use of generative AI. We see 2 of those in California, 1 in Utah, and 1 in Colorado. And the things that they have in common are focuses on transparency, right? Especially, again, with respect to the use of generative AI and content produced by generative AI. And of course, as Kristen said, regulation of dark patterns and manipulative and deceptive design. And when the FTC has looked at these issues, they have focused on design elements that induce false beliefs, hide or delay important information, lead to unauthorized changes in accounts, and of course, make it difficult to cancel subscriptions. So big challenges here in the United States, but we are definitely taking multifaceted approaches to address them at the state and federal level.
Great. It's a very complicated and comprehensive picture across the United States, as you're noting there. Just to the audience, we're getting some great questions. Please keep it up. We'll be getting to questions in the next few minutes. Mariana, I'm going to jump over to you. I'm really interested to hear what the Argentine government's approach is on children's privacy and AI.
Sure. Well, unlike the European Union, we don't have any AI regulation yet. There are some discussions taking place in Congress. Almost 20 bills were introduced in Congress, both sectorial and comprehensive initiatives, but without conclusive development. And my perception here is that probably in the coming year we will not have any regulation on AI, considering that the current administration of President Milei seems not to be in a position of fostering regulation that could be restrictive for the development of business, specifically considering that the AI is a priority for this administration. This is very different to what is happening in Brazil, which, as you may know, recently the Senate approved a regulation which is kind of similar to the EU AI Act, and now the House of Representatives will have to vote for approval of this initiative. In Argentina, we still have some guidelines. The Argentine Data Protection Authority developed and published in the last year the guidelines for public and private entities on transparency and personal data protection for the use of responsible artificial intelligence. It basically provides recommendations applicable to the different stages of the AI system lifecycle. There are also some ongoing investigations on OpenAI, initiated by several authorities in the region, particularly the Argentine Data Protection Authority, but also other authorities in the region, which leads us to consider that although almost every jurisdiction in the country has not approved a AI regulation, yet we still have the data protection rules. And in that sense, there are many countries such as Brazil, Mexico, Colombia, Peru, Chile, that have approved data protection law, and there are very strict regulations that will apply to the use of personal data in the context of the development or use of AI technology. So any company using AI or developing solutions based on AI should have to consider this regulation, which, as we mentioned before, when treating personal data of minors, you have to rely on a legitimate interest. And then we have the same problems that I mentioned before, whether and in that specific case, we have to just consider whether any specific regulation has a kind of a definition on the age in which the consent of a minor is valid, or whether we have to obtain the consent of the parents or tutor in a specific case. So, and there is no, I would say, a unified position of every country. So this is quite challenging for the companies doing business in the region, which have to just take in consideration the specificities of each jurisdiction.
Great, thank you. And in Canada, Kristen, what are some of the unique concerns around children's privacy and AI? And do you think that this issue is on the radars of Canadian privacy regulators?
Yeah, absolutely, Mike. It's very much on the minds of Canadian privacy regulators, and there's been some guidance to that end that's been released on this topic. So, in October of last year, our federal privacy regulator signed on to a statement specifically about AI and children, following a roundtable with other G7 data protection and privacy authorities. And the statement's well worth a read because it sets out what the G7 regulators consider to be relevant areas of concern involving children and AI specifically. So, a couple of examples are, as Mason alluded to earlier, children's particular vulnerability to the use of AI for manipulation and deception, being unable to discern and weed out deep fakes or challenge biased outcomes that result from AI outputs. Children and young people's increased risk of forming bonds with toys or online companions with AI integration has also been flagged, creepily enough, as a potential risk that we need to keep an eye on and that Canadian regulators will be keeping an eye on. The complexity of AI systems and how you balance that with enough transparency around how AI systems are developed and used, particularly for automated decision making, is an area that the regulators have flagged for consideration, and in particular, the difficulties that children and their caregivers may face when trying to understand how children's information is used in the context of AI models. And finally, the collection and use of children's personal information to train AI models is another area where the regulators have said they'll be watching. And in particular, they're critical of data being scraped from quote unquote publicly available sources like social media, or from captured or being captured from connected devices. So, again, an area where organizations might face some scrutiny. And last but not least, our regulators did jointly release principles for responsible, trustworthy, and privacy protective Gen AI technologies. And there, very clearly, the message is that organizations that develop and sell AI, but also organizations that deploy and use Gen AI in their businesses, must give particular consideration to their mutually shared responsibility to identify and prevent harms to vulnerable groups. And children and young people, meaning teenagers, are specifically called out there. So, to echo a point raised earlier, privacy impact assessments are one of the key measures that are emphasized over and over in the guidance here. So, to the extent your organization's handling the personal information of children or young people, it seems to be, table stakes that you're conducting those privacy impact assessments for your various business activities.
Great, thank you. So we're more than 30 minutes in now, and we're getting some good questions from the audience. So why don't we move to some of those questions? And I really like this question because it sort of recognizes that the tension between user experience and I don't think anyone would question that there's a need for tighter protective privacy rules for kids. But the question is, how can companies ensure compliance with evolving restrictions on children's data collection while maintaining a user-friendly experience? And I'll just throw that out to the panel if anyone would like to take that one.
So I'm happy to take that first if you'd like.
Sure.
I think I agree. It's a very good question. And I also think it relates to the question about CAPA and the use of digital identity as a mechanism, right? I know when we're talking about regulation, it would be incredibly helpful if the law or the regulators just specifically said, here's how you comply. It's very black and white. Do this and you'll be fine. But I think from a US perspective, especially, the states and the FTC, for example, have been very mindful of this question, right? So it's more about safeguards and principles within your business and within your business processes and still to achieve your business goals. So it is about striking that right balance. So if you look at, for instance, obtaining parental consent, this is something that the FTC discussed with its CAPA amendments. It did indicate that there were a few mechanisms that, of course, have been in implementation for many years now that constitute and work very well for obtaining separate and verifiable consent, but that those weren't the only way and that they weren't going to prescribe businesses requirements for how best to obtain that consent, because also that can hinder development and innovation in that space as well. So I think it's really about being mindful about meeting the spirit of the law in the United States and implementing those safeguards, but in a way that is best suited for your business and your customers.
Great.
I'm happy to jump in on that one too, Mike, because we
Please,
had some
yeah.
interesting points come out in that deceptive design sweep that I mentioned earlier. In particular, our privacy regulator actually congratulated. So it was a name and not shame. It was a name and celebrate for Lego, looking at their website and their practices around providing privacy notices to children. And Lego used short videos where Lego, characters themselves were explaining to children in clear and simple language how their personal information would be used, when they should have a parent involved in making decisions around their privacy, and how, what to do if they had questions or were unsure about something happening online. So what our regulators have said is, listen, organizations, you spend lots of time organizing or developing your products and your services. You should put a similar level of effort into developing creative, age appropriate privacy notice and consent practices. So that was one example where they found that, you were meeting those transparency obligations while at the same time, doing something that I think enhances a brand and also helps parents and children understand what's happening with their kids' information.
Great, thanks. We just got a question on age verification, which I think is interesting because it's an issue in so many jurisdictions around the world. I know in Europe, certainly here in the U.S. And the question is, according to the experts, what are the most effective methods for age verification of users, according to expert experience? You guys want to take a stab at that one?
I can take a very quick, give you a non-answer, which is that our regulators actually have an ongoing consultation on age verification right now. So we don't have clear guidance on that point yet, but it is an area where we should in Canada very soon. And there's an opportunity to make submissions on that issue and be part of that study right now. So very much a TBD in Canada right now.
Okay, great. Consent is obviously a really important issue anytime you're involving AI use or data protection around kids. And we have a sort of a question along those lines. How can we demonstrate that we have obtained valid consent? I believe it might be different from country to country. Is that you guys' experience? I mean, does the rules for what constitutes valid consent, does that vary by jurisdiction to jurisdiction, and how can companies accommodate that?
Well, I make some comments on this, Mike. It's quite a very challenging topic. I mean, because it depends on the jurisdiction. In some cases, the consent must be given by an adult, by a parent or the tutor. In some cases, you have to seek consent of the child because an authority may consider that if you are obtaining the consent of the parent, the child is not authorizing the use of his or her data. So you have to analyze this on a country per basis. So it's very complicated in that sense. Besides that, probably in some cases you can rely on different legitimate on different legal bases. For instance, legitimate interest, while in other countries not. In the case of Latin America, most of the countries rely on consent because they were inspired on the European regulations before GDPR, with the exception of Brazil, Ecuador, and some other countries. So in those cases, you cannot use legitimate interest. You have to obtain the consent of the person, of the data subject, which in case of minors, it could be a teen or a child. So in that sense, this is not very easy to address, because if you are a multinational company, you must comply with any jurisdiction. And although some companies, according to my experience, may say, well, we are complying with the GDPR, and we know that in most of the jurisdictions in Latin America have followed the European model, this will not guarantee that you are in compliance with the law in that specific jurisdiction. So this is quite challenging. And also you have to recall that something that is very important, that is that once you obtain the consent, you have to just implement a record that shows that you have obtained the consent in each specific case, because many jurisdictions require this, or the authority requires this. So as you may know, there are many aspects to consider here.
Mm-hmm. Mason or Kristen, do you guys want to add anything to that, or?
The only thing I would add is, I think Mariano hit the nail on the head, right? Each jurisdiction is a little different. And so in the United States, because we don't have a unified, comprehensive federal privacy law, we're also looking to about 19 different state comprehensive privacy laws. Some of those states also have their own laws with respect to children's privacy, AI, advertising, etc. So it really is kind of trying to find the most common denominator, making best choices based on the factors that Kristen outlined, right? What data are you collecting? What is the average age? What are the unique considerations related to your product and the children and the potential impacts, and documenting those decisions, right? Why did you decide to go in a certain way? Was it a business practice? Was it an inability to implement a specific aspect that was going to cost you a lot of money? And what we found is that even if you're out of compliance, so to speak, regulators are willing to work with companies in the United States to help them, breach those gaps, to fill those gaps. And if they are a primary issue for the enforcers, they are giving folks time when they have reasons behind the decisions that they've made, and they have tried in the best way possible with their own business practices and policies to comply. They're willing to work with you. But it is very challenging, and it is very tempting to kind of throw your hands up and say, can't do this. But having those reasons documented and well thought through will benefit you in the long run.
So other than death and taxes, it seems like the one thing that's true in life is that data protection compliance gets more complex over time and more difficult. We're approaching the end of time, but I thought maybe we could take one more question. And there's kind of an intriguing question in the chat about jurisdiction. And the question is, how do we understand when our companies fall within a certain jurisdiction? Is it all business-based or based on the country where you extrapolate the data? I assume that's where the data is processed. I have no idea how to answer that question, but maybe you guys could take a stab at it.
Yeah, I can say for Canada, I mean, the answer is a lawyer's favorite. It depends. But what is clear is that at least under private sector privacy legislation, so we have one piece of federal privacy legislation in the private sector, PIPEDA, and then three provinces have their own equivalent private sector privacy legislation. Those are Alberta, British Columbia, and Quebec. The direction where the case law is headed is that an organization has to have a real and substantial connection to the jurisdiction where the legislation applies. So there's clear guidance that you don't need to necessarily have a premise. You don't need to be storing the data, at a data center in a particular province. You don't need to have personnel in a particular jurisdiction in Canada in order for the privacy legislation to apply. It's a case by case analysis, including, to some extent, the location of the data subjects themselves, but also factors like, are you advertising your services, or are you marketing to businesses, say if you're a service provider, or to end consumers in a particular jurisdiction? And if so, you may be found to have a real and substantial connection to that jurisdiction. So it's a little bit of a developing area, particularly at the provincial level, but at the federal level, the test is clearly whether there's a real and substantial connection.
Great, thanks. Mason and Mariano, any input on that?
Well, from Latin America, say that the lost here in the European approach on the extra, meaning that even if the business has not premises in the jurisdiction, it may be fall under the regulation of the country. If you, as Kristen already mentioned, if you are targeting products or services to that specific jurisdiction, and it doesn't matter if you have premises there, if you have services there, infrastructure there. It will be very important if you are just selling goods or services specifically to that market. And what we are seeing here is that it doesn't depend on whether the law specifically considers or provides for an extraterritorial scope, as for instance Article 3 of the GDPR. In the case of Argentina, we do not have a similar regulation because the law is very old and so on and so forth. But the authority, the Argentine Data Protection Authority, has ruled that even foreign companies doing businesses in Argentina with no premises in Argentina has to make a submission for registration of databases in Argentina and will be under the scope of the data protection law. So this seems to be the path or the criteria followed by many, not only the Argentine authority, but also authorities within the region, besides the fact that the LGPD in Brazil, the Ecuadorian law, and other regulations in the region are just copy and paste the European data protection regulation.
Terrific. Well, I think that brings our time to a close. I'd really like to thank Privacy Rules, a great organization, for putting together this webinar on kids' privacy and AI regulation issues. I'd like to thank our three terrific panelists, Kristen Pennington of Macmillan in Toronto, Canada, Mason Clutter of Frost Brown Todd in Washington, D.C., and Mariano Peruzzati of OHAM BF in Buenos Aires. This has been a great discussion. Really appreciate it. I've learned a lot and really appreciate your insights. And thanks so much.